when I filed the petition, many media people tried to call me to come on air, and I refused because I respected the privacy of the proceedings as articulated in by Dateba in the Ajay case. So this is the first time that I'm actually coming on TV to say something about this petition, which I thought was poorly handled. Now, you talk about my petition did not have evidence and so on. This is false. I not only had facts, but I provided dates, events, and I also indicated witnesses that I was going to bring along during the inquiry phase to substantiate the allegations that I was making. Because when you submit a petition to a president, you are not attaching evidence, because the president is not a trier of fact. You are submitting enough to let the president decide whether or not there's enough in there to push the matter to a body that can inquire into it. Okay, so when I come in there and I say, look, the Chief Justice, and before I even say that, let me acknowledge that, look, the removal of a Chief Justice is a grave matter. I certainly will never be part of any attempt to remove a Chief Justice unless I was absolutely convinced that there was a good reason to do that. Second, people often talk about judicial independence, and I agree with everything that they say about judicial independence, except when they talk about judicial independence, they are always talking about institutional independence for the executive trying to intrude into the affairs of the judiciary. That is one facet of independence. But there's also decisional independence. And in decisional independence, the Chief Justice or any person can interfere with the proper or independent functioning of a judge or a judicial body. That is decisional independence. And that was the basis of my petition, that the Chief Justice had unconstitutionally inserted herself into the naming of Supreme Court justices. There's a very good reason that when you read the Constitution, it doesn't include the Chief Justice in this process, because the Supreme Court is supposed to be a court of equals. Every member of the court is an equal. The Chief Justice is the chief, largely because she also performs administrative functions. But when it comes to their judging, deciding cases, each panel member has one vote. Each panel member is an equal. And you can see the mayhem and the bedlam if indeed judges started coming to believe that they have to play ball with the Chief Justice because the Chief Justice has a role in whether or not they are going to sit on the Supreme Court. It was unconstitutional and the gravest breach of our Constitution for the Chief Justice to name specific justices and write to the President, unknown to us until the letter was leaked, that I want A, B, C, D, E to be appointed to the Supreme Court. Why A, B, C, D, E? And look at the embarrassment that you bring to some of the judges who you've named, because some of the judges were actually sitting on political sensitive cases at the time. And to name them gives the appearance that the executive and the judiciary are in cahoot to promote people who are sitting on political sensitive cases. So that was a serious breach. And that was the only reason I filed the petition. It gives me no joy whatsoever. In fact, it's painful that I would submit a petition for the removal of a Chief Justice. But where the Chief Justice gives me no option by involving himself or herself in the naming of Supreme Court justices, that's just one leg of my petition. The second leg was in the reconstitution of panels that have already started hearing cases. If you read the Constitution tells us that once a panel starts to hear a case, that panel cannot be changed. In fact, the Chief Justice has no administrative authority over that panel. He couldn't tell them, sit today, or I'm moving one person out of the panel, because if she did that, and if we allowed a Chief Justice to do that, the Chief Justice will be interfering with the decisional independence of court panels. I mentioned specific cases in which this had happened. I indicated in my petition that I'll bring Justice Jamafe to testify about these things. And then third, I raised the question of how decrees were being used to regulate the courts, contrary to the Constitution. The Constitution says, look, if you are going to issue any directives about how courts should operate, do that with a constitutional instrument, and it specifies an elaborate process. The reason for that elaborate process is because we don't have an imperial Chief Justice who can just do whatever she wants. The Chief Justice is subject to the Constitution, and if you want to if you want to come out with a rule, there's a rule-making process. You have to meet with the Judicial Council. You have to have a constitutional instrument. It has to be laid in Parliament. It has to take a certain number of days to ripe, and then once it ripens, it becomes the law. But the Chief Justice was on her own doing these things, and this is the reason why I got involved. And I thought that if that or those things that she was doing were not addressed in a very fundamental way, we stand the risk of allowing future Chief Justices to do that because of the precedent that had been set by her. There's a reason why from Redu through Aqua to Georgina Wood to Sophia Kufu to Ani Yeboah, none of them ever attempted to name somebody to the Supreme Court, because they knew that was fatally and incurably flawed and wrong and unconstitutional and constitutes a violation of their oath of office.
Former president, and I just need to make the clarification that you referenced the president. I think this the former president, Nana Dankwa Akufo-Addo, is the one you petitioned. In all this clearly elucidated positions that you have just espoused, he concludes that your petition was deemed frivolous, vexatious, and unmeritorious. That was his conclusion to your petition.
That is laughable, because
is it laughable?
Ask yourself, yeah, of course it's laughable. Ask yourself, after that petition, do we know whether it is wrong, or by that petition are we saying that future Chief Justices can reconstitute panels? Are we saying that future Chief Justices can send names to a president on who to appoint? Why this particular justices, not others? I mean, on the Court of Appeal, we have very experienced and very astute justices. Sir Dennis, for instance, comes to mind. Why would a Chief Justice overlook Sir Dennis and go and suggest some other person who is Sir Dennis's junior, not just in terms of tenure, but in terms of accomplishments? If the Chief Justice is allowed to do that, can't people understand and appreciate the toxic culture that would have been introduced into the judiciary, where every member of the court will now be trying to please the Chief Justice, something that the constitutional framers were keenly aware of and did all they can to say, no, we are not that kind of institution where the Chief Justice decides who should be promoted. Rather, let's leave that to the political branches to decide who should get nominated to the Supreme Court and the Court of Appeal and so on. It is a grievous violation of the Constitution. It doesn't happen anywhere. It is not a light matter. You see, one of the things that I think we get fixated about is if something does not involve money, then people cannot see that there's a big issue. They say, oh, well, but there's no money involved. There is no breach of the Constitution as serious as a Chief Justice becoming the person who combs the court and decide who should be appointed to the Supreme Court or who should be promoted. Once you allow that, you compromise incurably the independence of the judiciary, because now all the judges are trying to please the Chief Justice, because you know that if you get into her bad books, if you are not in her good books, she's never going to recommend you for promotion. And that is something that we want to avoid. Are we saying that, or is that President Akufo Addo saying that he doesn't think a committee should inquire into why court panels are reconstituted to the protestation of the parties in the case, and often in a way that gives the hint of political, a political flavor? He doesn't think that is a serious thing. This, to me, was so fundamental that anybody who understands what a prima facie determination is will laugh when you read what was written in that. The Council of State, my uncle, I love Uncle Sam. I mean, I go to see him whenever I'm in Ghana and so on. He's very good to me. But he, before they determined the prima facie case, was out calling the petition stupidity. That's what he said. And you think the Council of State was independent in that determination? They are not independent. That was just some prefabricated determination, because any neutral panel would look at it and say, well, look, these allegations are serious. We don't know whether they warrant a removal or not. A committee should look into it, because the matters that have been raised are very fundamental to the health of the judiciary. And if we don't resolve them, we will create a precedent where future Chief Justices come in and then they start naming people to the Supreme Court. They start reconstituting panels. They start transferring people and so on. So I thought there should have been more outcry at the president's determination of no prima facie case.
In your petition?
And in my petition, yes. And in the current petition, where there is a prima facie determination, I mean, that makes sense, because the prima facie determination is such a low threshold that unless somebody is motivated by malice, they would make a good case. I mean, in my case, I had no malice. I don't have anything against the Chief Justice. In fact, I like the Chief Justice. I like the Chief Justice. And it pained me when she was doing some of those things. So as far back as maybe January 2024 or maybe later in 2023, I started making public announcements that these panel reconstitutions must stop. Justice Jamafe shown the red card, it's not good. Opuni judge transferred, it's not good. Imperial Chief Justice, stop. I made repeated efforts to get to her to stop some of the things that she was doing. It was only when I concluded that she was not going to stop and that I had a civic duty to intervene, that's when I filed the petition. No petitioner is happy to file a petition. And I don't know about the president, but if I were to assume, no president enjoys being conscripted to determine a prima facie case, because they are sitting somewhere minding their own business, trying to push their agenda. But when the petition comes, they have no option. The Constitution mandates that they look at the petition, send it to the Council of State, and determine a prima facie case. And like I said, the standard for prima facie case is not adjudication. It's not the duty of the president to say, well, the Chief Justice did this because Rule 4 allows the Chief Justice to do that. How do you know, as a president, are you a judge? Are you don't know any of these things. You are simply to determine a prima facie case, and anything that you say that is adjudicatory in nature, which the president's prima facie determination, not the current president, but the former president, was pregnant with adjudicatory remarks, biased remarks. That response that the president gave to my petition is one that lecturers should use to teach their students how not to determine a prima facie case under Article 146.
You reference Justice Senyon Jamape a number of times. Just to establish it, is it a meeting you had, or as whether you've met him before, or as just a reference to a particular position that he took in previous instances?
No, it was not it's not reference to a position that he took or whether I've met him, but he was one of the victims of this panel reconstitution.
Okay.
And so I was going to subpoena him and then put him under oath to try to explain to us what happened.
Right.
I was actually going to subpoena the former president to try and establish whether there was collusion between him and the Chief Justice to name these people to the court. And then there was some plot whereby the Chief Justice was supposed to originate the names, and then the president would probably say, well, I don't know, it's not my decision, the judiciary wanted.
Okay.
I was going to do all that. That is why the inquiry was important.
The question is whether you are going to consider resubmitting your petition to President John Dramani Mahama. Which was...
Well, again, following my stand on Article 146, I'm not going to disclose whether I will submit it, whether I've submitted it, whether I'm thinking about submitting it, and that will remain private.
Very well.
Well, that's respected, but then again, because, and let's put it on record, that yes, indeed, this is the first time you are speaking about your petition on any media platform, and we appreciate that. But then again, you hear the former president in that response to your petition essentially taking the position that the Chief Justice's conduct that you cited and haven't explained quite clearly why you depart in thought and in position from Nana Addo Dankwa Akufo-Addo and the then Council of State position on your petition. He says that the Chief Justice's administrative responsibilities really under the Courts Act were found to be consistent with the law and established practices based on what she had done. So why then again do you raise questions about it?
Because that's exactly my point. The president is now a judge. He says, oh, okay, based on your petition, and I found out later on that the Chief Justice had responded. I never saw the Chief Justice's response, so I was not able to rebut her her response. But the president is now a judge. He's saying, well, I think that the Court Act, I don't think that the Court Act supersedes the Constitution. When the Constitution says X should happen, I don't care what some Court Act is saying. And frankly, the Court Act that he quoted, he misquoted that. The Court Act doesn't say that. So everything that the president said, I disagree with completely. But that's not the point. The point is the president should not put himself in a position where he's now a judge, saying, well, I don't believe what the petitioner is saying. I believe what the Chief Justice is saying. Here is what the law is. That is the function of the committee that is supposed to inquire into the allegations. Only the committee is supposed to inquire into the allegations. Especially in my petition, where I allege that the Chief Justice improperly sent names to the president. So the president should have been sensitive and say, well, look, I'm even involved in this thing, and I want a committee to come out and establish that there was no wrongdoing.